Welcome to the Kids Caught in the Middle video series. Today's episode, we're going to cover Chapter 3, Post-Judgment Custody Modifications. Hello, my name is Liisa Speaker, and I'm the author of the book, Kids Caught in the Middle, How Families Are Harmed When Judges Don't Follow the Law. Now, custody law is designed to erect barriers to having custody changes. But what we see in the family law context is that most of the litigation actually occurs in the post-judgment context. Why is that? Well, I have a theory, and a lot of times the families, when they're getting divorced, for example, they are ready to get it over with. They are motivated to settle because they're ready to move on with their lives. So they have a settlement for the divorce. But then fast forward 2, 4, 6 years, and there are a lot of changes that have happened in the family, including that maybe the parents aren't getting along, which obviously prompts the post-judgment custody motion. There are 3 main steps to any post-judgment custody modification decision. First, the trial court must decide whether there is proper cause or change of circumstances to meet the custody threshold under Vidvarka v. Grassmeyer. Second, the trial court must decide whether there's an established custodial environment and who that environment is with, one parent, both parents, or neither parent. And third, the trial court has to consider the best interest of the child. Now, these 3 steps lead to some problems which we see a lot of on appeal. Sometimes, for example, we see the trial court applying the wrong threshold standard. Where, for example, if they say, oh, this is just a parenting time modification, therefore they only need a preponderance of the evidence to change quote-unquote parenting time, even though in reality the change is significant enough that it really is a custody modification. We also see a lot of problems where trial courts do not make a finding on the established custodial environment. And that leads to the problem with us not knowing which burden of proof even applies. Should the trial court have applied preponderance, or should it have applied clear and convincing evidence? So those are some of the issues that we see on appeal a lot. One of my pet peeves in the post-judgment custody modification arena is the entry of temporary orders. So what happens a lot of times is that a trial court will do a change of custody order on a temporary or interim basis. But the problem is they do that without having any evidence and without making any findings. And remember, there are many findings that are required every time there's a change of custody, even if it's on a temporary basis. So there has to be findings on the threshold, on the established custodial environment, and on the best interest of the child. So one of the big problems with these temporary or interim orders made without any evidence or findings is that they stay in place for a really long time. So instead of having a hearing within a week or a month, the hearings are delayed, and sometimes it takes over a year to get the final custody decision from that hearing. And in the meantime, the child is living in that new custodial environment, not only during the course of the trial court litigation, but often during the course of the appeal as well. The book also covers some very frequently asked questions of me when parties are in the trial court getting ready for an appeal. For example, is a threshold evidentiary hearing required? And can the trial court consider evidence that existed before the last custody order when the trial court's considering the best interest of the child? And also, what is the result when the Court of Appeals vacates or reverses the trial court decision? To get a handy guidebook that we designed specifically for attorneys and judges in their family law cases, you can click on the link below.